It was a Tuesday morning when the letter arrived. The kind of letter no homeowner ever wants to see. It wasn't a reminder about a late fee, nor a polite request about a neighborhood event. This was an official enforcement action from the HOA, demanding that a 75-year-old decorated military veteran vacate his property within 30 days. This wasn't just an inconvenience. It was an assault on his constitutional rights as an American homeowner. His name was Harold Burrows. Harold had served 2 tours in Vietnam, earned a Bronze Star, and returned home to a quiet suburb where his father had worked hard to build a life. His property sat at the end of Maple Ridge Drive, a modest ranch home on land his father had purchased through a Veterans Land Grant back in 1950. His property rights had never been questioned until now. A new HOA board had taken control of the neighborhood just 2 years earlier. And with that new power came relentless enforcement actions targeting longtime residents like Harold. First, it was his fence height. Then, the color of his mailbox. A flagpole he'd installed became a violation. But they didn't stop there. They escalated it. Each violation came with a fine. First, it was $50, then $150, and, soon enough, it was $500 per month. Within 14 months, Harold found himself facing more than $8,000 in fines. Fines he knew were completely fabricated. It wasn't about the fence or the flagpole. No, this was about pushing him out, financially and mentally forcing him to sell. And when Harold refused to pay what he called fraudulent charges, they took it a step further. They filed a lien against his property, claiming authority over the unpaid assessments, citing CC&R violations. They sent Harold a certified letter demanding he pay the full balance, or they would initiate foreclosure proceedings and take full enforcement action against his home. Harold stood on his front porch, holding that eviction letter in his hands. He wasn't panicking. He was calculating. Harold knew something the HOA board didn't. His late father, Sergeant First Class William Burrows, had purchased the land in 1950. And the original property deed, still on file at the county recorder's office, contained legal language that would make every single enforcement action, every fine, and every lien against Harold completely void. But Harold wasn't going to show his cards just yet. Not until they push him too far. And push him they did. HOA President Diane Kessler escalated her misconduct to a new level. She sent Harold yet another certified letter, informing him that the board had approved a special $12,000 assessment against his property for additional architectural violations. The abuse of CC and RS was intensifying. Harold's alleged total now exceeded $20,000. For a retired veteran on a fixed income, the financial burden was crushing. The litigation costs seemed insurmountable. But Harold understood something the HOA didn't. Their entire chain of enforcement was based on a legal fiction. Harold's daughter, Rebecca, a paralegal, drove up from Richmond the next weekend. She found her father at the kitchen table, surrounded by every notice, every fine letter, and every piece of certified mail the HOA had ever sent him. Harold wasn't panicking. He was methodically building his foreclosure defense file, document by document. Rebecca wasn't surprised by what she found. Harold had been thorough. But when she looked closer, she realized how badly the HOA had messed up. They had violated multiple due process laws. No proper hearing notices, no appeals, and no compliance review documentation. Every enforcement action against Harold was procedurally defective from the start. "Dad, we need a real estate attorney right now," she told him. She could see the storm coming, and it wasn't just about Harold anymore. This was going to be a fight, and the HOA had no idea what was coming for them. They hired Martin Hale, a property rights attorney with 22 years of experience in civil litigation and HOA disputes. Hale wasted no time. He ordered a full property deed search, and that's when everything changed. The search uncovered the turning point. The original deed from 1950 contained an explicit restrictive covenant tied to the Veterans Land Grant. The language was clear. Harold's property was exempt from any future HOA jurisdiction unless the title holder voluntarily signed an annexation agreement. No annexation agreement had ever been signed. Not by Harold, not by his father, not by anyone in the entire chain of title. The HOA's enforcement authority over Harold's property had never existed. Their entire lien authority was built on a house of cards. Hale immediately understood the magnitude of the situation. This wasn't just about defending Harold's property. This was a counterattack. It was time to file a quiet title action, demanding a court ruling that the HOA had no jurisdiction over Harold's property. Hale prepared a 14-page attorney demand letter, outlining every due process violation, every instance of CC&R abuse, and every unlawful enforcement action the HOA had taken against Harold's property. The letter included a formal damage assessment, calculating Harold's losses, emotional distress, legal fees, and a fraudulent lien at $175,000 in total damages. It was a devastating blow, carefully calculated. When Diane Kessler received the letter, she had no idea what had just hit her. The HOA board immediately panicked. They called an emergency meeting. The minutes of that meeting, later uncovered through legal discovery, revealed pure fear. They asked whether their title insurance would even cover this magnitude of claim. The financial exposure was catastrophic. But Diane Kessler refused to back down. She said that backing down would set a dangerous legal precedent. She wanted to fight. And so, the legal battle officially began. Hale filed a petition with the county court, asking the court to rule that the HOA had no jurisdiction over Harold's property and that all liens, fines, and enforcement actions were legally void. He also filed a civil lawsuit for tortious interference with property rights, emotional distress, and breach of covenant. The HOA had failed to verify their jurisdiction before pursuing enforcement against Harold. The HOA quickly retained its own counsel, but the attorney immediately recognized the severity of the situation. He advised the HOA to settle immediately, but Kessler refused. She insisted on fighting. That decision would lead to the HOA's total financial ruin. A court-ordered financial audit exposed even more alarming findings. Harold wasn't the only homeowner targeted. 7 other properties on Maple Ridge Drive had been subjected to similar fines and liens, all without proper compliance review. The HOA's actions were systematic and widespread. The arbitration clause in the HOA's own governing bylaws required mandatory mediation before legal action could be taken against any homeowner. The board had ignored this requirement in every single case. Every enforcement action against Harold and the others was procedurally invalid. At the first court hearing, the judge carefully examined the original 1950 deed. She reviewed the entire chain of title and, more importantly, the absence of any annexation records. The judge then asked the HOA's attorney one simple, devastating question. Can you produce any document showing that this property was lawfully annexed into your HOA? The attorney could not provide any such document. The court immediately granted Harold relief, halting all collection efforts, removing the fraudulent lien from his property record, and prohibiting the HOA from any further enforcement actions. As the case gained momentum, the HOA's attorney urgently recommended settlement talks. The HOA's total liability, including damages, penalties, and claims from 7 other affected homeowners, had exceeded $600,000. The HOA could not survive this legal battle without total financial collapse. Diane Kessler resigned from the board the next morning. 2 other members followed suit. The remaining members unanimously authorized settlement negotiations, bringing an end to Harold's long, hard-fought battle. Harold received $192,000 in compensation, covering legal fees, emotional distress, and the damage caused by the fraudulent lien. The HOA issued a formal written apology, and the court entered a final declaratory judgment, confirming that Harold's property had never been subject to the HOA's jurisdiction. The deed restriction from 1950 was upheld. Harold used part of his settlement to install a new flagpole in his front yard, taller than the original, flying the American flag alongside his old unit's banner. The battle was over. Harold's victory had set a legal precedent that would protect homeowners across the county. And what's the lesson here? Know your rights. Know your property deed. If you don't, you might find yourself in a battle like Harold's, where your rights are tested and your fight is against more than just a group of neighbors. It's against an abuse of power. So, what would you have done in Harold's situation? Drop your thoughts in the comments below. If this story moved you, share it with someone who needs to hear it. Let's talk about it.